It's The Law with Morelli Chertko, and joining me today from Morelli Chertko Lawyers is Scott Hugabart. How are you?
I'm very well, Howie. Thank you.
You practice wills and estates, business and real estate law. We're going to be talking about wills today, and most people think that they know what a will is. I think there's a lot of misconceptions. So let's start with the definition of a will.
You're right, Howie. There are a lot of misconceptions. A will is really just a legal document that's executed in a particular way and witnessed in a particular way that allows someone to express how they want their estate to be dealt with once they pass away.
I imagine you hear of so many people that just don't have it together. They put it off, and they continue to put it off. Why?
For lots of reasons. For lots of men, it seems to be that if I go to make a will and it's like an admission I'm going to die someday, and for many of us that's a difficult thing. But it seems to be just one of those things that's easy to put off.
Is it true that if I don't have a will, everything's going to go to the government?
It's not true, Howie. It's one of those misconceptions that so many people have. But the truth is, if you don't have a will, then you don't have input on where your estate goes, and there's a scheme set out in the government's legislation that says where your assets go, and that may or may not be what you really want.
Who should I include in my will? Who do I have to include in my will?
You need to think about everyone in your family that you care about, but in particular, who you need to include in your will are your spouse and your children if you have children. There are laws that set out that anyone who is a spouse or a child of someone who passes away who doesn't think that adequate provision has been made for them in a will, that allows them to apply to court to vary your will. So when you're making your will, you really want to think about the obligations that you have to your spouse and your children, and if you have ideas about excluding someone, that's a discussion you need to have with a lawyer.
Does it play out at all like Hollywood, where the family is sitting there and someone is doling out what is on the estate or what is in the will, and to you I leave the Hot Wheels collection, but to my favorite daughter I leave the $3.5 million?
Again, it's a question that we receive all the time. Someone will pass away and a family member will phone up and want to know when the reading of the will take place, because that's what they've seen on TV. And TV and the internet is a place where we get lots of our legal knowledge these days.
Medical advice too,
yes. Yes, I know I drive my doctor crazy. I go there and I say, I've been reading about this on the internet, and he just rolls his eyes.
Dr. Google. Yes, and you always think you've got the worst possible thing. With the internet and there's a lot of kits out there that are available for wills. There's information on the internet. But really, why should someone go to a lawyer like yourself rather than try and do it with a kit or online?
Quite a number of reasons, really, Howie. One is that you really only get one chance to get it right. Once you've passed away and your family finds out that you haven't done this correctly, there's no way to correct that. The second is that you get a chance to have a discussion with your lawyer about the dynamics in your family and some special considerations that you may want to make in your will, whether it's a child that has something that maybe gives rise to a concern about them inheriting a large sum of money. We see that all the time, whether it's alcoholism or addiction or something else that gives rise to a concern, whether it's entitlement by one of your family members to a disability pension. And when you're speaking with a lawyer, you can find the best way to actually ensure that your estate reaches your family.
How do you deal with that? A younger person or someone who may be troubled youth, the person who has passed still wants to leave a large sum of money or just a sum of money to that person, but they need to wait.
We most often use a form of trust. For most people, when we say the word trust, they think of something terribly complicated. And for most people, it need not be. A trust that's established in a will is called a testamentary trust, and those can be as simple or as complicated as the circumstances dictate. Most of the time, they'll be fairly simple, and to go back to your example, someone who has some difficulty in their life will most often establish a discretionary trust that allows the person that you choose as your trustee, whether that's the same as the person you've chose to be your executor or someone else, to have some discretion in deciding whether to advance money to that person or not.
Are there people that think that they've got their papers and their will in order, but really they should revisit it because circumstances have changed?
Certainly circumstances in people's lives change, Lots of people, when they're younger, they make a will and they name their parents as the executors. And, at a certain point of time, their parents age out of the ability to do that. And, there'll come a time when they need to look at maybe siblings or other close family members to take responsibility. And then finally they'll make a will where their children are now adults and responsible and able to take that role on. And of course, people die, and people's assets change, and people's marital circumstances change, and all of those things are cause to take a moment and revisit your will or review your will with your legal advisor.
I imagine that you need to know what your assets are. I mean, a lot of people kind of forget about certain investments. Maybe they inherited something themselves that they've kind of forgotten about. They've got something stored away in a safety deposit box. Before I come and see you, what do I need to get in order to sort of speed up the process, or at least make it a little easier?
That's a great question, Howie. When someone comes to see me, what I hope they bring with them is not necessarily a list of everything that they own, but an idea of what it is they own and how they own it. Whether they've got investments and whether those investments have designated beneficiaries attached to those, or whether they're jointly owned with other people. The most important questions that we sometimes ask is how people own assets. If they own them jointly with others, then those assets may well not form part of their estate. If those assets have beneficiary designations, they may well not form part of their estate. And so when we think about those things that pass outside of the estate, quite often it will lead us to take a look at what we're going to do within the estate to make sure that overall the objectives of the person who's making the will are met.
Okay, anything else about wills before I let you go today?
Probably just most important that you make one. The government does have this scheme that sets out what happens if you don't have one, but you really lose control of that if you don't have a will. So it's just really important to have one.
Thank you so much for joining us today.
Thanks, Howie.
Scott Hugobart from Morelli Churtco, and It's the Law.